some of the cases that are allocated to them, not everything. The second part of the system is the evidence management solution, which is the case lines, software, which is an integral part of the end-to-end solution, Court Online. The Court Online system is piloted in Gauteng Division of the High Court, and this division represents over 50%, 52% of civil cases in all the high or superior courts. The rollout of the system is planned for the MTEF period, and the project is mainly supported and funded through the IJS. In support of this project, a procurement process was initiated in 2021 for the evidence management part of the Court Online, which is the case line system, for the 36 months contract for licenses, which included support and maintenance. What this point means that initially when we procure case lines, it was for 36 months with the reseller, and which was piloted in Gauteng Division as a standalone, not operating as two parts, CRM Dynamics as well as the case line combination. So I'm just clarifying this so that it is clear that the Court Online, as I've said, two parts, one case line, one CRM Dynamics. But this 2021 piloting in Gauteng was only a standalone case line for 36 months with a reseller, which expired in March 2022. On the 10th of December, following a sole source procurement process, we awarded a contract to Thomson Reuters to provide the software licenses and resources and support maintenance, including professional services for a period of 60 months, commencing 1 April 2022. This was post the 36 months contract expiry, which was in preparation for the next phase of piloting the total solution, now in Gauteng, in preparation for rollout nationwide. In terms of the award to Thomson Reuters, which is an international company, was required to subcontract 30% of the services to a qualifying small enterprise, QSE, and EME exempt micro enterprise registered in South Africa. On the 20th of December, Treasury was informed as per the rules about the procurement as contemplated in instruction number 8 of National Treasury 8 of 2007-8. On 25th January 2022, Treasury informed us that it was not in agreement with our procurement process. An extensive engagement ensued between the OCJ and Treasury, in part, which also included participation of CETA and Microsoft, who is tasked with the development of the total solution, including the CRM part. And the engagement ended up in a mediation process, which later the National Treasury agreed with us and noted the deviation accordingly. Thomson Reuters commenced with their licensing services on 1 April 22 with the support and maintenance to start on 1st June. And on the 16th of May, Thomson Reuters, as prescribed, informed us that of the subcontractor, formally provided OCJ with details of the QSE-based company that is subcontracted for support and maintenance. And at that stage, it was noted that the company that's subcontracting through Thomson Reuters is 3 directors of the company are employees of the OCJ. And we followed the due, SEM followed the due ROPS, which is the remuneration, what is called remuneration workouts. Yes, there's a policy relating, I'm not able to call it properly, but there's a policy relating to doing remuneration work whilst you are inside the public service in terms of the ethics policies of government. By then, the 3 directors of the company that was subcontracted, ZA Square, were still employed by the OCJ and were already serving resignation by the end of May. Following the above, Obviously, subsequent to that, we formed a task team of senior officials convened by myself, which was subsequent also to what I have indicated in the last slide, as well as the media issues that were raised. I think there were a few articles that appeared in the media around this issue relating to the contract as well as the 3 officials. And we dealt with that. We issued our statements, etc. Following that, I convened the EXCO and selected a team of officials with whom I will work with to begin to review and assemble the documentary trail pertaining to the contract and the award. As you would understand that the officials, the 2 officials or the 3 officials mainly who had played a major role in the contract had left. And we created a first deliverables and events timeline for contextual purposes. And our forensic unit was activated, which undertook subsequent investigation. And investigations are ongoing, and the OCJ is therefore not in a position to provide any further information, as this may also negatively impact the investigations. And also to indicate that the OCJ, the forensic unit, is also busy with the documentation. I think maybe to pause here, Honorable Chairperson and members, that it will be difficult for the OCJ to disclose most of the issues relating to the investigations, as it also involves the part of the work that is being done, as well as contractual issues, as well as possible litigation or even processes that could end up with PRECA and other related legislation that impacts on what has happened, which is subject to investigations. I would ask the committee's indulgence in that regard. In due course, when the investigations are completed, I myself will present to the committee on the facts as they appear, as they come out of the investigation, so that the committee is on board. The next slide deals with business continuity to prevent any interruption in services. The OCJ engaged with Thomson Reuters also, who committed to ensure that the services that are already supposed to be to be rendered are not interrupted. And Thomson Reuters, the contractor, subsequently informed us through the media release also that they have also, on their part, instituted internal investigations, and that the services provided by the subcontractors at a square is suspended until further notice, which is the case up to now. And there were non-payments made by the OCJ in terms of this contract in view of the issues that have arisen, and in view of the investigation, and in view of the consequences that will follow out of the investigations. From a business continuity point of view, maybe just to highlight some of the facts. As I've already indicated before, we had case line which was standalone, piloted in Gauteng Division, Joburg and Pretoria. And we were moving in March 2022 when we procured with Thomson Reuters for the final piloting of the total solution, meaning we're moving from standalone now to the full component, meaning the CRM dynamics as well as the case lines together being piloted in Gauteng from March, so that we prepare for the rollout outside Gauteng to the other superior courts. Now, in terms of the status of the pilot, I could just share few statistics just to give an indication of where we are. We have over 3,373 law firms registered in the system. We have 4,735 portal users, which is the users, meaning the litigants, the public, the lawyers, etc., excluding the judges and the staff. We have over 182, a combination of 82 active judges and 100 acting judges who are already trained and registered in the system. And as at 9 o'clock today, we have over 17,000 cases issued in the CRM system to date. So we have a bulk of the system of the civil cases. Active cases are actually the total population of active civil cases in the Gauteng division are in the system. Governance, ethics, and risk management. Given the crisis that we faced, the EXCO was called to reflect on the risks that we have faced that has materialized in this instance, in this procurement, and its potential impact on the judiciary that it serves. And in this regards, I have ensured that we put in place certain mechanisms to make sure that our internal controls, as well as our processes, our SOPs and policies, are strengthened. The executive management, executive committee is looking at that, as well as our management, to ensure that we check where would some of these gaps that would have eventuated the situation occurred. This is work in progress that we have engaged on. We also implemented this risk-based approach so that the potential risk to mitigate the adverse impact on the judiciary is also looked at. And maybe whilst I'm here, in terms of the risk with the judiciary, is the unfortunate part that for which I stand to apologize to the judiciary for it, because of the name of the institution. When things like this happen, the name of the institution, being the Office of the Chief Justice, directly impacts as if it is the judges or the Chief Justice involved in the administrative side of things, a matter which I think will need to be looked at. In terms of strengthening of internal controls, we take the fiduciary duty to manage and protect state resources entrusted to us seriously as the OCJ. We are reviewing all the supply chain management processes. We are looking at the membership of the relevant committees in the bid processes to ensure that we found ways to enhance the technical capacity and strengthen further internal controls in SCM, meaning that we have now, as EXCO, also identify SCM as a high risk in our institution to be looked at closely. We are conducting a review of contracts, especially in the ICT space, as it is where most of the money, as we know, technology is very expensive at its products and services. To this end, we bear the responsibility to ensure that where perception and wrongdoing is established in the procurement processes, and that we will identify that, and based on legal counsel that we are under, determine the best way forward, guided by obviously the prescripts that we have to follow. Also, just to indicate that we have counsel that we have, through the state attorney, acquired, with whom we work with, and we take counsel on the issues related to this matter, as it is already a contract that is in place, so that we are able to manage all the risks and ensure that as the investigation ensues and as we come across information that needs to be dealt with in terms of the risks, in terms of the institution and impact, we are able to take proper legal advice from senior counsel in this regard. So we take in the very cautious approach because these matters have serious implications going forward. In closure, Honorable Chairperson and members, we commit that we will ensure, myself and the EXCO, that we take a prudent approach. And with regard to details, I've already indicated specific details we cannot be able to disclose them at this stage. And we are not saying so because we want to hide anything. As I've said, I commit that at the appropriate time, and based on legal advice, I will myself lead the team to account fully on what actually happened in this instance. We value the oversight by the portfolio committee and we undertake that any impropriety in the use of public funds will be addressed, and we are prepared to account fully, as I've already indicated. The audit committee has been briefed also on this matter, and they are aware of what I have just presented to the committee today. Thank you very much, Honorable Chairperson. I will pause there and take questions from members with my team.
Thank you very much, SG. Members, before we proceed, I forgot to inform the committee about the apologies that we have received. We have an apology of Honorable Engelberg, who might be joining us late. He is attending another meeting. And then we have an apology of Honorable Janji, who is chairing the Section 194 committee. Honorable Ngola is with us, but he is shuttling between us and Section 194 committee. Those are the apologies that I have received, members. Committee Secretary, do you have any additional apologies?
No, Chair. I'm not sure about one.
No apologies, Chair.
Okay, thank you very much. I think the apologies would be noted. I have the following members. I have Honorable Dennis Breitenbach, Honorable Werner Horn, Honorable Swart, Honorable Nieuwoud Drogens, in that order.
Thank you, Mr. Chair, and good morning to everybody. I am somewhat perturbed by this presentation. It does not impart a lot of information about this matter, and this matter is obviously a matter of deep concern. So I understand that there's an investigation that's ongoing and that information should not be given that would compromise that investigation. I do think, though, that the Office of the Chief Justice has been particularly parsimonious with the information that they've shared with us today. Everything they've shared with us today, we could have read in the newspapers. In fact, we have read in the newspapers. So I'm not feeling at all enlightened by this presentation. I'd like to know from the Office of the Chief Justice, and I might have missed this in the presentation, these three positions are very senior positions. Have they filled them? Have they advertised them? Are they filled? Are there people performing this job? And if so, who? And where did they come from? I'd also like to know how three such senior members of a not very big organization can plan and leave simultaneously, submit their resignation simultaneously, I presume, or in very short shift of each other. How this could not have raised red flags, how questions were not asked about this mass resignation of three very senior members. Did they do exit interviews, and if so, what were the results thereof? And then did these three staff members disclose their interest in the company Zero Square Consulting? If so, when? What was the nature of that interest? Did they declare an extraneous income, or was there no income? We need a lot more information in this regard. This is a serious matter, and it's mystifying how three such very senior members, such very high profile, in the public's face members could have I don't know, planned this thing without it being detected in the normal course of business. So I'm really not feeling at all comfortable. I'm not feeling like I know any more about what's going on here. And I'm not feeling like the Office of the Chief Justice has a handle on this. And it appears that everything that they're doing is retroactive, and there was nothing that was done that was proactive. And I'd really like a lot more information on that. Thank you, Mr. Chair.
Thank you, Honorable Breitenbach. Honorable Horn.
Thank you, Chair. Good morning from my side. Chair, let me at the outset say I share the sentiments of the Honourable Breitenbach around the scantness of the information supplied to us this morning. It's one thing to say the Office of the Chief Justice value the oversight of this committee, and then it's another thing to 2 months after the news broke, come and basically share the information that's already publicly available, and then say we must just trust processes to unfold, and that further information cannot be shared because that could have an impact on investigations. So I think the first question that must be answered is exactly how far is the investigation? 2 months down the line, with the first focus being on a very specific procurement, one would think that the basic facts around this would be simple enough for the investigation into this to have proceeded far enough for us to be afforded sufficient information to have oversight. And then in line with that, a few specific questions. The presentation talk about a sole procurement process. So the question is, at what stage or at what time did the Office of the Chief Justice make the determination that this would be the type of procurement where a sole procurement process is to be followed? And ultimately whether the subcontractor that ultimately is at the nub of this specific matter was by then already established. Then specifically the question is in respect of making the decision that there's a sole entity that ultimately qualifies to be awarded the contract, was the 3 members, who ultimately is also seemingly the shareholders of the subcontractor, involved in the decision that there's only one company that can provide this service. So one talks about, if one now wants to refer to the lingo that is used, bid evaluation and bid adjudication. So in simple terms, were these 3 members involved in those processes? In terms of the subcontractor company, are these 3 members the only shareholders? And if so, what is the percentage of shares they respectively hold in the company? In terms of the references to possible litigation, the one question that has not been answered is, what is let's say the status of the award? Is that still in place with an understanding that the subcontractor must be replaced? Has any payments been made in terms of the contract? And if so, what percentage? And if the contract is still in place with the let's say the sole service provider, to what extent has services then started? And then finally, reference is being made in respect of this scrutiny of other contracts. Can we be afforded information as to whether any indication at this stage has been identified, or whether there is any indication that improper actions also were present in awarding other contracts of the Office of the Chief Justice, and if so, which contracts are in play there? Thank you, Chair.
Thank you, Honorable Horn. Honorable Swart.
Good morning, Chair. Good morning to my colleagues, and good morning to the Secretary General. Thank you for the presentation. But I do want to share my colleagues' concerns about the lack of information. There's a lot of information in the media, and maybe I do appreciate that there's an ongoing investigation, but we need answers. And Chair, it could be that in responding to these questions, maybe the Secretary General can respond in writing, but I do share the concerns that we're not any nearer to what has happened. In fact, there's far more information in the media, and we actually need to thank the media for exposing this, because the question arises, had they not exposed it, would it actually have been exposed or come to light, given the fact that there appears to be approval for tender deviations? And we know, in terms of the Public Finance Management Act, that the Secretary General must ensure procurement and provisioning that is fair, equitable, transparent, competitive, and cost-effective. And of course, the Secretary General also apologized in as much as it is an office of the judiciary, the Chief Justice's office. And yes, we need to reiterate that this is a separate department from the judiciary, but the impact would require the highest level of integrity when it comes to supply chain management and procurement practices. Now, that having been said, I think it's very important for us to mention that we know that from the media that this company was formed 5 days after the contract was awarded to Thomson Reuters. 5 days by these high-level members of the department. And that was on the 15th of December 2021. Surely there should have been some red alarm or some red flag there. Now, the former Chief Financial Officer is reported to have said in a news article that he saw no issue with him overseeing the bid adjudication committee of the OCJ and then later winning the contract with Thomson Reuters. How can that possibly be so? And there was also a comment from Mr. Stubbe, the former case management, the former Chief Director of Court Administration, that because their contract began on 1 June, the company had not earned any income until the employment at the OCJ ended. So I appreciate these issues are all being investigated, but it smacks of the highest level of what would appear to be impropriety. And that was pointed out by the Zondo Commission into state capture, the issue relating to procurement. So that having been said, I think the issue which is now before us is, was when the office of the CJ appeared before the committee on the 3rd of May, I would like to know whether the office was then, whether Secretary General, you were then aware that 3 senior staffers, the Chief Financial Officer, the Chief Director of Court Administration, and Case Management Director had resigned at that time. Why were we not advised at that stage? Secondly, I think it's important, Mr. van der Born's question about the filling of those vacancies at senior management level. When will that be attended to? This is a small organization. How can you operate without these senior officials? Thirdly, I understand also from media reports that it is estimated that the investigation will take 3 months. Is that an indication so that we can get greater clarity on this issue? And then there is an issue relating to the 1 April 2022 National Treasury Supply Chain Management Instruction, Enhancing Compliance, Note 3, which was issued to reduce the abuse of supply chain management system. Was this applied in this situation? Yes, it was before that, but is this part of the process that will enhance supply chain management? That note, 1 April 2022. Thank you, Chair. For the time being, that will be my questions, and I'm sure we will need to engage later on these issues, given the fact that we were not given much information because of the pending investigation. Thank you so much, Chair.
Thank you very much, Honorable Swart, Honorable Chele. Oh, sorry, Honorable Nivot Drachen, and then Honorable Chele. My apologies.
Thank you very much, Chairperson. And good morning to everybody on the platform. And good morning to the officials from the OCJ. Thank you for your presentation. Okay, Secretary, if the frames keep moving. I would like to add my concerns and share the sentiments of my members, of my colleagues who have spoken before me, that there's scant information that has been provided today. But yes, we'll respect the process that an investigation must ensue. I don't want to raise the same questions as my colleagues. However, I do want to understand who was on the team when the bid was adjudicated or evaluated. Were these three officials participating throughout this entire process? And was there, at no time did they declare their participation or their involvement in this procurement? And then secondly, when did the OCJ pick up that there is some kind of issue? Is it when it was exposed by the media, or did OCJ have some kind of suspicion before this matter went public? The SG says that you're going to be evaluating the contracts that have been awarded. Have you discovered anything so far in this evaluation? And then what raises, because of this situation, does it mean that the funds that are allocated to this project will be suspended, or are you continuing with the process? Does this mean that, the services will continue, considering that they were supposed to start earlier, or are you going to suspend the services? Because of course, these are critical services for the users. Another question of mine would be that, does the SG have enough internal support so that all business processes can continue? And, or did other staff members perhaps in the team also pick up any irregularities? Thank you so much, Chair.
Thank you very much, Honorable Nivot Drachen. Honorable Maseko Chele.
Thank you very much, Chair. Good morning, colleagues, and also to the SG and the team. Chairperson, I have only a few questions that are maybe clarity questions. I think, let me just piggyback on the last question of Honorable Verma. Sorry for that. In terms of being aware of what is happening within the procurement services or within the OCJ as an institution, do we? I just want to find out that was there any sign of something wrong that is happening before this occurs? Maybe that they might have been aware of, that they maybe did not take it serious, in terms of how the things are done in terms of procurement. because this gives me the impression, Chair, that maybe this was not the only one. Maybe there has been other procurement services that has been these three officials have been involved in that maybe were not flagged to the institution that there is something wrong happening there, because it also gives the impression that this has been done intentionally. These officials had enough time to do this, as I suspect that it is not the first time, Chair. I would like the SG to comment on that one. And then also, Chairperson, my question is that to the SG, the three officials have, because when from the presentation we hear that when they became aware of this matter, the three officials have already submitted their resignations. And I wanted to find out that, was there anything done in terms of the pension funds, payment of the pension funds, holding them or making them, because this thing has been done intentionally, that maybe to make sure that we don't suffer loss, Chairperson. Was there any intention of maybe saying holding the pension fund or anything that was due to them, to those officials? I think that is the only question that I will end up with, Chair. Thank you.
Thank you very much, Honorable Chele. SJ, and maybe just one question. Who is doing the investigation? Is it an internal investigation, or are you using the law enforcement agencies? Over to you, SJ.
Thank you, Chairperson. Can you give me? Thank you, Honorable Chairperson and members. It is really a very difficult day, but we have to account. I will deal with, I will club some of the questions that are related to one another with your permission, Chairperson and members. And in areas where we will not be able to offer direct, I will indicate so. The feeling of the three positions of the officials being filled, and I will deal with that also with regard to the question that related to who is now doing the job and the capacity issues. The three positions became vacant at the end of May, and they have already been advertised. The CFO, the Director Case Management, as well as the Chief Director for Court Administration, who was also the spokesperson of the Judicial, as you know. The positions have been advertised. We are in the process of filling them. The advertisement have already issued, closed, and they have closed. And we are in the process of interviews as well as the later processes, with a view to ensure that they are filled in the next month or two. Obviously, taking into consideration the assumption of duties and the notices for those who will be coming in. So they have been advertised. I can give the dates of advertisement was in June already. Yeah, all three of them were advertised in June. So they will be filled in the next 2-3 months. The question relating to now who's doing the job, it is a matter that I have also, as we are a very small department, the total of the SMS members is even under 40, I think with 38. And with the 3 that have left and the work that they were doing, two of them sitting in the core business, which is called administration, obviously left a gap. So I have taken the decision to appoint an acting CFO from within the finance team, as well as the acting for court administration. One of the directors in court administration is acting. Ms. Sharia Nagul is acting, Ms. Paula Morabit is acting CFO, and Ms. Valerie, what is Valerie's name? Nakale. Valerie Nakale is acting in the director case management position. So there are acting positions, there are acting persons in these three positions already, who happens to be three African ladies. So this has an impact that now obviously a gap is lost behind because of the gap that they have to step in. So we are trying to make sure that we cover all areas whilst we are struggling with this. As you've already seen in my presentation, I indicated that I put a team together, and these three are part of the team that I'm working with, being a small department, to work on this matter. This matter is also under investigations, as already indicated, and some of the officials, there was a question on who was sitting in the bid adjudication, in the committees of the process of adjudication. These officials also, may I mention, honorable members, that they are also part of the investigation which the law enforcement agency is looking at, which answers the question, are we investigating internally? Yes, internally we are, as well as law enforcement agencies involved. So these officials are also under questions by the investigation team. And I would appeal to the committee that I don't raise names so that we leave the investigation to deal with what it has to deal with. At the appropriate time, I promise you, I will be able to give you the details, because this is public information that you desire. Whether the official disclosed their interest during the period of this process, the answer is no. When they were sitting in the processes of procurement, obviously there are requirements that you declare whether you have any interest. They declared that they have no interest in the company or in anything relating to the process. And that ties to the question whether we knew in advance. We did not know. I did not know until the matter was already, people were already resigning, and the company was informing us about the subcontracting situation. So we did not know in advance. We did not suspect, I did not suspect there was anything untoward that was happening. And I had no reason to suspect that anything was untoward, because I did not find anything that, in my view, would have given me reason to believe that they were doing anything untoward. But obviously, it's human nature. What happens, that happened. And the directors are the ZA Square subcontractor is the sole, they are the three sole directors according to the records. And their share division is that Mr. Ngube is 51% shareholder, and Mr. Kutzer is 25%, and Ms. Van Meeker is 24% shareholding, the total of which is 100% for the three of them. What was the other question that I want to link to this? The question was raised of the role played by the three in the procurement process of the TR or Thomson Reuters contract. It is a fact they all played a role, both from the bids specifications to the bids evaluation, as well as the BAC, as it was part of their official duties, including the negotiation process for the pricing relating to the contract. So their footprint is, fingerprints is everywhere in this procurement process. They were integrally involved with the contract. There was a question raised whether the contract review we have picked up anything untoward. As at today, we have not picked anything, but the process is still unfolding. Preliminarily, we have not seen anything untoward. There is one case that we are following on that was in the media on PKC, which we are looking at, which relates to one official who had left earlier also. But the matter is also part of investigation, which we will not dwell into the details until we're there. A question was asked about the status of the contract with Thomson Reuters and whether payment has been made. There hasn't been any payment. As soon as I became aware of the situation, I did not process any payment in relation to this matter as a risk management decision, so that should anything come out later that is going to put this contract in jeopardy, one would have protected the state funds. So no funds have been paid. The status of the contract, we are subject to legal counsel, and maybe also to indicate that we are also in engagement with the contractor, Thomson Reuters. Us as a team and our counsel and their team and their counsel are engaging. So this matter impacts exactly on what the engagement is going to be with regard to the contract. So legally speaking and technically speaking, the contract is on because the services are required. There was a question asked about the impact on the cost. As I had already indicated, I think the statistics with regard to the impact on the court. We have done an impact assessment as the OCG as part of the work that we're doing relating to this contract to assess what is going to happen in the event that we don't have a system like case lines. And the outcome of the assessment is that, as I've already indicated, currently we are piloting how in the total solution, meaning we've shifted from the standalone case line to now case line as part of the integral part of the system. 100% of the total population of civil cases in Gauteng Division of the High Court is in case line, is in the court online e-filing system. That 100% represents, as I've said, by this morning, over 17,000 cases, and it's still growing as we speak. It must have gone up. So if we look at this number, and it's a total population of the civil caseload of the division, which is the biggest division in the country, the impact will be devastating. So dealing with this contract, we have to move very carefully, not because of the company, but because of the service that we need. And it is our discussion with our counsel and the team that the approach that will be taken must ensure that the court does not suffer, because that is the most important part. Because the over 600 or so law firms are already registered. And there is also over 150,000 outcomes, court case outcomes that are in the system that will be affected. We cannot go back to a manual system. That cannot be an option, because we don't even have the storage capacity to do that. The practice directives issued by the Judge President of the division on civil is really on ensuring that all civil matters goes on the system. So the system was at an advanced stage that it will be quite really sad if we have to lose those cases. So the question now becomes, what do we do? We are working, as I'm saying, my team and counsel and the contractor are working on a solution to ensure that the impact is not great. As I've already indicated in the presentation, we have agreed that the services must continue whilst we sort out the issues that have occasions for us. 4,750 lawyers are already in the system and registered. So that will be the impact. So we are prioritizing making sure that whilst we look at and address the procurement issues that are rising to save the system and make sure that the courts are able to function properly and go forward. There was another question that there was a question whether I have enough support to continue the services and whether any irregularities have picked. I think I've commented on that. I do not have sufficient support in view of the gaps that are occasioned by what is happening. And I think the capacity really also talks to the budget cuts that the OCJ is faced with regards to the COE, which also impacts on the other services budget cuts. It is not easy to replace positions as and when they become, in general terms, as when they become vacant because of the ceilings that have been put on COE, which is a macro issue relating to the reduction of the wage bill. We understand that. But to answer the question directly, I don't have sufficient support, but I have a team that is dedicated to ensure that we can cover all the areas that we can under the circumstances. Did the evaluation of the contract show any improper conduct? I've already alluded that not at the stage when the processes were unfolding. It was only after the fact that it was realized that the three officials were involved in this contract as interest. With regards to the question relating to the pension funds, may I stay clear of that because the law enforcement agencies and the investigation are dealing with that part, and at the appropriate time I will disclose what is the position with regards to that. There was a question relating to the CFO and the court administration chief director relating to the comments that they made in the media that they do not see anything wrong in what has happened. I think as the OCJ it is quite very clear. I do not agree with the sentiments that they express, but I would try to reserve my comments so that I can allow the processes that are going to unfold appropriate time, not to ventilate these issues in the public space. And I would like the committee to indulge me in that regard. Still, of course, I've dealt with. The SCM Treasury note to reduce the abuse of the system. We have implemented the instruction note as the OCJ. And our engagement and discussions with the National Treasury on these issues also, I think they have contributed to them making sure that they clarify some of these issues in these notes. Not that we take credit, but we are saying that we have contributed in the clarity that they had to make sure that it is given. There was an issue raised relating to the sole provider. Whether how do we establish that fact or whatever, it's a matter that is under investigation as information that the investigators are collecting relating to the interactions that happens between the OCJ and the company that has been contracted. So may I stay clear of this one. At the appropriate time, I'll inform you what has been uncovered. Is any other thing that I have left?
There was a question from Honorable Breitenbach on the exit interviews.
Or the exit interviews, we can provide that information later, but I'm doubtful. The general practice that one has discerned in the department is that people don't really disclose much in the interview exit. In the review that we have done in the past, people just indicate personal reasons or they indicate pursuing other interests without disclosing much. But we can, I have not necessarily looked at their at their exit interview. We can provide that information later on. One question related also to us providing a written report that I agree with, that at the appropriate time a report in writing will be provided to the committee, and that they deserve to know what has happened and went wrong. The PFMA responsibilities of the accounting officer are acknowledged, and they stand clear in the act, and which so far we have tried, or I have tried as the accounting officer to ensure that I guard against, but these things do happen. It is a lesson that we are not proud of, and as I've said, immediately we convened at EXCO to begin to look at what are the internal controls tightening up that we need to do to ensure that these things, procurement policies as well as standard operating procedures are tightened in this regard. I have addressed the bid adjudication committee and to also impress upon them that the SCM as well as the technical people in these processes need to play a major role and be allowed to make sure that some of these things are identified far in advance. And I must also mention, honorable members, that we are a very small department, and sometimes it becomes very difficult to get more people into the processes because the only way to make sure that people don't play major roles in many areas is when we have many officials at the appropriate level to be able to do these things. And when we have to rely on external people, our processes take too long because people commit and people have their other priorities where they work, and it becomes very difficult for them to commit. So being a very small department also is a risk, but we cannot do procurement and not do procurement because we are afraid that people will be playing major roles. Unfortunately, it is the nature of where we find ourselves in. I am not making it as an excuse that we should not be prudent, but I'm just highlighting the fact that one of the issues that impacts on that is exactly the fact that we are a small department, and being a small department, unfortunately, when you see that an official has played a role in the process, a prominent role, it raises eyebrows, but the context is that we are a small department, otherwise it becomes very difficult. The maintenance and support, there was a question around this, the services of the subcontractor. The maintenance support by the subcontractor has been suspended, and the main contractor is the one providing the services. And as I've said, we are busy engaged with our councils, both sides, on the contract status so that we can resolve that issue, and as well as priority defending and making sure that business continuity and the system of civil in the high courts of Gauteng are not negatively impacted. Those investigations, I think I've answered that. I've indicated they did not declare their procurement, and that we were not aware during the process of the procurement processes of their interest in the company. They did not inform us about that in advance, and in the forms they indicated that they had no interest. And at that time, because we were not aware, there was no reason for us to suspect that there was anything. Scrutiny of contracts, I think I've covered. Status of the contract. Did I answer the shareholding?
Yes, you did. You did give us a breakdown of the shareholding.
I don't know if I've skipped anything, Honorable Chairperson and members, that I did not.
Yes. Honorable Swart asked about the 3 months that was said the investigation is going to take 3 months.
Oh, yes, that we are expecting that the investigation should be concluded by the end of September. So by the end of September, we'll be able to give guidance. To give information on what the status is. And I think because we had committed to 3 months, even if these things do happen, even if it's not completely 100%, will still indicate what the status of the investigation outcome is.
Thank you very much, SJ. I have Honorable Swart, Honorable Volksdruchens, and then Honorable Horn in that order.
Thank you, Chair, and thank you, SG. I appreciate the difficulty in being able to answer questions with a pending investigation ongoing. What I would like to just ask you, when the OCJ, when you appeared before us on the 3rd of May, I asked a specific question. Were you aware at that stage about the resignations, given the fact that they took effect on the 31st of May? And if so, why were we as a committee not taken into confidence that 3 senior members of your executive, your chief financial officer, chief director of court administration, and your court management director had resigned? If you weren't aware, then when did you get the letters of resignation? That's the first issue. The second issue, I really appreciate your explanation about the civil cases, the case lines, impact, and Chair, I'm in agreement. There's no ways that one can go back to a manual system. Gauteng is the center of our economic hub. It is hugely important for economic growth. That civil litigation, I myself have been involved in litigation using case lines. It's very, very effective. And I just wanted to find out if the SG has given us an impact study, but if I understood her correctly, she said there's no payment on these contracts. So if there is no payment, is there not a risk? And you indicated that there is ongoing discussions with your counsel, with your team, and with the company involved. Is there not? What is the actual risk if you're not paying that the service could be stopped? I think it's a very, very pertinent question, because one doesn't want to have that impact. And then, Chair, we would need some form of regular updates on progress. I'm not sure I'll be guided by you and the committee, but surely given the extent and the impact and the possible impact on civil litigation in Gauteng, we would need regular updates, maybe in writing to you, Chair. I'd be guided by you. Should it be a fortnightly basis? I'm not sure, a monthly basis, as to progress with this investigation, and most importantly, any impact on civil litigation, particularly in Gauteng, and then of course on other litigation across the country. We may also need to engage with the judiciary itself, the Chief Justice himself, as to an understanding of the impact on the courts. Thank you, Chair, for that.
Thank you very much, Honorable Swart. Honorable Volksdruchens.
Thank you, Chairperson. I left out one question. The use of, I'm trying to understand the use of local company, and at what point in time when you awarded the contract, at what point in time did you want a local company? And then in the recruitment, do the bid adjudicators investigate the companies that are chosen, what skills they have, when were they established, and if they are capable of doing the job? Or, you know, if it's just a new company with no staff, no resources, and doing the job that the main tender required. So, and in terms of the local company, I just wanted to get clarity on that. Thanks, Chair.
Thank you very much, Honorable Volksdruchens. Honorable Horn.
Yeah, thank you, Chair. I have a few follow-up questions. The first, on the issue of the shareholding, I would want to know whether, as part of the investigation, the shareholding also a focus in the sense that on the one hand, there's of course the possibility that the shareholding was set up in the way it has been in order to qualify as the BEE subcontractor, but on the other hand, there's also the possibility of silent partners, and specifically then the majority shareholding being a proxy holder, or also on behalf of some unknown person. So I would want to get the assurance that that is part of the investigation. The second question I have, Chair, is in follow-up to the answer on the exit interviews. I mean, I understand that ordinarily exit interviews would be somewhat of a non-event, but in the specific circumstances, there was, of course, a context of 3 senior managers resigning simultaneously. So apart from the standard question as to why are you leaving us, or I would think that these specific set of exit interviews should have entailed also an interrogation as to why are the 3 of you leaving at the same time. And then on the issue of declaration of interests, Chair, I also just want some further clarity. I understand that there's, of course, the standard form to be filled in whenever you serve on any internal body that deals with evaluation, and prior to that, hopefully even when you start drafting terms of reference or bit specifics. But in the current circumstances, one would think that in terms of senior management, even if it is a small department, there should also be an annual disclosure of interest. And I have it that some media reports have confirmed that happened in April. So I would want to get a confirmation, firstly, whether a general disclosure of interest happened indeed in April, and whether that specific disclosure of interest, if it happened, whether that indicated any indication as to shareholding in the specific subcontracting company. Thank you, Chair.
Thank you very much, Honorable Horn. Honorable Glenis Breitenbach.
Thank you, Chair. I'm struggling to unmute, sorry. Yes, I must say that the Secretary General has been at pains to share as little information as possible, and having difficulty with the phrase, she'll share with us at the appropriate time. This is the appropriate time. This committee has an oversight duty over the Office of the Chief Justice. This is a big deal. This is not some small matter, and I know that she does realize that, but to say to us, she'll share with us, or the office will share with us at the appropriate time, is, I found mildly patronizing. As to say that office will decide when and how to share information with the body that has oversight over them. I must say that I'm somewhat affronted by that approach, and I find it unsatisfactory, and it has placed us in a position now where we are unable to exercise oversight over this entire affair. We've been told nothing that we didn't know before. We could have read all of this and have read all of this in the newspapers, and we're no closer to unraveling the problem. And if the answers to these questions are not available, then I'm afraid to say neither is the Office of the Chief Justice any closer to unraveling the problem. And to suggest that in September, yes, they'll come back and inform us of the status of the investigation, that's a non-thing. To come back and inform us of the status of the investigation is either it's finished or it's not. I don't have that much interest in the status of the investigation as what I have in the content of the investigation. How this happened, why this happened, what has been done to prevent it happening again, and why it wasn't picked up. Those are the things we need to know to exercise oversight. Not the status of the investigation, or to be told that at the appropriate time, information will be shared with us. It's very easy to hide behind an ongoing investigation. It's not a valid excuse. There's no necessity to share information that would jeopardize the investigation. But a lot more information can and should, and in my view, must be shared on this platform regarding this matter that will not jeopardize the investigation. And so my view is simply that the Office of the Chief Justice does not have a handle on this issue, does not fully understand what has happened for reasons possibly not of their own doing, were caught napping. And 3 senior members of their staff resigned simultaneously that raised no red flags, nobody asked any questions, nobody was worried, nobody investigated, and they haven't even looked at the exit interviews. So those are my views. I don't have any questions because the answers will be at the appropriate time. We'll share with you the information. So I don't need that answer, but those are my views. Thank you, Mr. Chair.
Thank you very much, Honorable Maseko Chele.
Thank you, Chair. I think Honorable Breitenbach has covered me on the last one, that it's important that the SG must up the issue of, being careful of these things happening within the department, because if we're going to get answers which says what happened, it really makes us feel like everybody does whatever they like within the department, and the outcomes thereof will be such, and it will shock us even in future if we don't follow up on these issues and watch exactly close the processes of the department. But Chair, my question, my other question is on the issue of updates. I wanted to find out from the SG if updates on the review of is there any update on the review of the supply chain management processes, and if maybe was there any gaps which have been identified to date, or maybe any remedies in terms of the gaps if they happen to find anything wrong within the space, Chair. And also, have they, if there's anything that might be prevented, or the remedies, in terms of the remedies, have they asked or the assistant from the Auditor General?
Honorable Chele, we could not hear you after the Auditor General. Can you repeat what you wanted to say?
Okay, I'm sorry for that, Chair. My question is that the progress report on the review of active contracts, if there's any impropriety, Chair, if they can check that one, particularly on within the information technology, communication technology, and also, Chair, give us information on. Thank you, Chair. Okay. Lastly, the plans that they might be, maybe because they are aware that there's a serious problem in those areas of procurement. Do they have plans in terms of monitoring this closely, Chair? The issue of procurement. Thank you.
Thank you very much. SJ.
Honorable Chairperson, I think I had forgotten Mr. Swartz, Honorable Swartz issue around when we appeared on the 3rd of May, whether we knew, and the answer is no, we did not when we met with the portfolio committee on the 3rd of May. The letters of resignation were received in the HR on the 3rd and the 4th and the 6th of May, which was thereafter. The risk with regards to not paying the contract is a matter that we are discussing with our councils. We are understanding of the risk of a breach of contract, etc. But both the OCJ and Thomson Reuters sit with a problem with regard to this company and the 3 officials. So the invoices will be considered within the context of that. The fact is, yes, services are being rendered. The fact is, yes, the system is operating, as I've already indicated. and lawyers and judges are using, the users are using the system. Therefore, technically speaking, we have to pay the services that we have been receiving. But I am not comfortable, subject to counsel, to be just paying under the circumstances without OCJ and Thomson Reuters resolving some of these issues, which with regard to that. And I am committing that I'm aware of the risk with regard to paying, which I am managing together with our counsels. On regular updates on the impact of civil litigation in Gauteng, I'll stand to be guided by the committee on that to understand the impact of the case lines and the situation that we are faced with on the courts. But I can assure the committee as we sit that the case line system or the court online system is operational in Gauteng, in both Johannesburg and Gauteng, as it was supposed to be. As I've said, the subcontracting is not done. I mean, the phase, what is this? So the phase level 1 and 2 services, which are supposed to be given by the subcontractor, support and maintenance are being given as they should. The only difference is that it's not by the subcontractor, it is by the Thomson Reuters themselves. I'll be guided by the committee on the updates. We will be ready to do that on the updates, but as today, there isn't any negative impact yet. There was a question relating to did they investigate? Does the investigation touch also on the setup of this company and the silent partners and the unknown people being involved in that? The investigation also involved by the law enforcement agency also involves the contractor. It's not only us on the side of the OCJ that we are subject to the investigation. The Thomson Reuters also, and what they have done with regard to subcontracting is also part of the investigation. We are aware that they've been raised. The law enforcement agency have asked them questions on relating to this matter, and for fear of my answer becomes the same, that things are in the investigation space. I do apologize and understand the frustration. I am at pains also to want to share also the information with the committee, as it is your role in terms of the Constitution to do oversight, but I will be compromising the investigation. I have taken counsel also before the committee to be advised on how one should deal with this, because there is one is sitting between a hard rock and a hard place in terms of being able to provide information at the same time, not affecting the investigation, as well as the advice that counsel is cautioning us against with regard to the company, the subcontractor, the OCJ, and the impact thereof, that we shouldn't ventilate issues which could later be ventilated in the courts, because there is possible litigation that is going to come out of these issues. And under that counsel advice, I appeal to the committee to understand. I understand the frustration. Any person in your position will feel the same way. The local company, yes, according to the records at our disposal, the subcontractor had no trading experience, and therefore they did not, as a local company, they had traded on the first day after they had left the institution. I take the criticism on the exit interview, but maybe the context is with limited capacity and with the crisis that one is faced with, one has to make choices to focus on the most difficult aspects of dealing with the procurement issues and the risk in SCM that one has faced. But as I've indicated, one of the DDG for court administration is here. What he shares with me is that the chief director court administration indicated that he's going to private practice. I think that was verbal. We will still check the interview, exit interview, but as I've indicated, usually our our experience is that you don't get much out of that. I take the criticism if the committee is of the view that I neglected that part, but there were more urgent things that one needed to look at. On the disclosure of interests, which all SMS members and other officials below that are prescribed to disclose, I confirm that the 3 officials did disclose in their end of April 2022 disclosure, which they did on the last day, 30 April 2022, before the system closes. I take the criticism from Honorable Breitenbach for the frustration that you are enduring with the committee with regards to not being able to share the information. And I think the track record of the OCJ speaks for itself. It's not because we are trying to hide anything from the committee. I really appeal that one is sitting in a very difficult situation. I appreciate this happened under my watch. I take my responsibilities seriously, but I appeal that we let the process unfold, and I will present myself to be grilled at the appropriate time. And I understand how you feel about that. With regards to this having happened, what are the gaps that have been identified and any remedies or the plan to close this in the SCM? We have indicated, we have identified in the SCM because of capacity, lack of more officials in that space, so that we are able to segregate some of the duties, and which also impacts what I've already said with regard to sitting in the committees. You end up having people sitting in different levels because we are a small department. And as I've said, getting people from outside is a problem. It delays our procurement plans, it delays our processes. It is not an excuse, but I'm saying that this reality we are faced with. So that is the SCM, and we have tightened the SCM and increased more senior managers to do oversight over SCM, so that more than one eye can look at these things. Also, we have put in place mechanism whereby the risk management unit will also look at the companies as soon as they are going to a certain level of evaluation, at the evaluation stage before the adjudication, so that the companies can be looked at through the applicable systems and not rely only on the forms on conflict of interest declarations, because as you would understand, tender documents are too huge. It will be very difficult to really, with the capacity we have, do everything, but we have put in place that mechanism. Risk unit is under instruction to ensure that any company that goes through the procurement system must be checked on the side of us officials' involvement with the companies, on the other side, on the company having had any involvement previously with any of us, and their capacity to be able to deliver. I don't know if there's any other question that is left behind. What is it? Or how has the help, we asked for help from the AG? That's the question that I think is outstanding. The Auditor General did, obviously subsequent to the story in the media, contact us, and we have with them looked at the we looked at the environment with regards to ICT, and we have asked them, we agreed with them that going forward, they will also make sure that when it comes to ICT, where the money, the bulk of the money is spent, as well as where the risks are, given this incident that has happened, that they will look at. They have identified certain areas in ICT which will come out of the audit report, and we will deal with that at the audit reporting stage in this instance. But they did contact us when it comes to this issue, when it hits the papers. I've done with the disclosures. Chairperson, I'm your hand. I don't know if there's anything that one did not look at, one did not respond to.
No, from my side, I don't see any, unless members would indicate if one of their questions is not answered. Honorable Swart.
Chair, I just wanted your guidance. Maybe we can discuss the follow-ups in as much as regular reporting to the committee as to progress and impact on civil litigation. I think that is very important, but I'll be guided by you and the committee as to how regular that should be. Thank you, Chair.
Okay. No, that was going to be part of the way forward. Thank you very much, Honorable Swart. Thank you very much, Honorable, in fact, SJ, and to your team. We do understand, and I think you also understand the frustration on our part. We take the work of the judiciary very seriously and its reputation very seriously. What has happened is unfortunate, but we also do understand that investigations are continuing. And you have indicated that from the look of things, by the 30th of September, the investigation might be done. So what we would do is to schedule the first engagement with yourselves and the office of the Chief Justice in the first week of October when we come back for the BRRR. We will schedule you so that you can update us on the progress and also on the issues that have been raised on the case lines, the civil litigations, how they impact, how are they impacted. And so we would meet with you, and then we will, after receiving that report, we will discuss the frequency of report thereafter, whether they would be in person or be in writing. Because I'm looking also at the trying to balance the gravity of the situation that is faced by the Office of the Chief Justice and the ability of the committee based on the work that is before it, that we might not be able to have every time we meet with you, have a meeting. Maybe sometime we would, upon discussion, accept a written update. But the first update in October will be a full meeting with the committee where you will update us. And then we will decide as to when do you come back again, either in a form of a written report or in a form of a full meeting. I think that would be all, members.
Thank you, Honorable Chairperson and Honorable members for your time.
Sorry, Honorable Swart. Honorable Swart.
I am in agreement with the proposal, but I would ask the SG if there's any danger about case lines or anything that happens in the interim that we should be alerted immediately in writing, because we would obviously, legal firms would be contacting us if there's a problem. So you've given us the assurance that it shouldn't happen. But Chair, with your permission, would that be in order if there is any problem in that regard? Thank you, Chair.
No, that's fine. No, that's fine. That's fine, Honorable Swart. And I will accordingly distribute the information if it is shared with me. Thank you very much. Thank you, SG, and your team.
Thank you, Honorable Chairperson and Honorable members, for the time. And I apologize for frustrating you with the responses. And I understand your frustration. I take it seriously, and I assure you that we do our best with limited resources to correct what has happened. and ensure that it does not recur going forward. And I publicly apologize to the judiciary, which administration I lead, for such an occurrence, and we will continue to ensure that the integrity of the judiciary is not affected. Thank you so much.
Thank you very much, SG. Members, can we take a 10 minutes break? Then we will start with the land court bill. I'm not sure whether Mr. Roberts, maybe we will call you when we are done, because it might take some time. Or maybe members, you would have received an opinion yesterday on the cannabis bill. I'm not sure whether we should start with cannabis or we should start with land court, so that we can discuss that opinion, because it has got an impact on how we will need to process the bill. I am in your hands. Mr. Duprez, I see your hand.
Good morning, Mr. Chair. Thank you very much. And I apologize for interrupting your discussion with your committee members. But with regard to the note that we've submitted in respect of the land court bill, I think we will be able to do that fairly quickly. So we would like to propose to the chairperson that we might stand down after Mr. Roberts had the opportunity to take the committee through the opinion, because I think that might need a bit more time, but we will be able to run through our note, if I may use that word, fairly quickly within 10 or 15 minutes. Thank you, Chair.
No, that is a very good intervention, Mr. Duprez. The 15 minutes one is a very good intervention. It's encouraging. Members, I'm in your hands. Just before we break, but I think Mr. Duprez has assisted us. I'm in your hands, Honorable Swart.
Jay, shouldn't we then do the land court bill after the break? That's 15 minutes, get that finished, and then we can move over to the cannabis bill and spend all our time on that.
Okay, there's a contrary view, Honorable Yako.
I think whichever one will be expedited first, we should do, and then the latter one we then do, so that we can spend more time on it.
Okay. No, I think members, let's do it like that. So we will come back at 11:10, and then we will do the land court bill, followed by the cannabis bill. Thank you very much. Let's meet at 11 minutes past 10.
Okay, Mr. Chair, I'm just going to share the screen with you. Thank you, Chair. Mr. Chair, we have submitted this document a couple of days ago to the committee. I'm not going to go through it line by line. With your permission, I would rather like to speak to the document itself. But just by way of introduction or background information, the committee or a number of interested parties expressed their concern regarding the proposed exclusive jurisdiction of the Land Court as a court of final instance in exclusion to the Supreme Court of Appeal, and then the issue of a compulsory arbitration, which is currently contained in the Land Court Bill as introduced, and then also the possibility of bringing the expropriation bill under the exclusive jurisdiction of the Land Court. We make reference to previous meetings of the committee in paragraphs 1.2 and 1.3, and then I would like to highlight in paragraph 1.3 that the committee also requested the department on 25 May this year to conduct research and do a briefing on the concept of equity. And Mr. Chair, I apologize, but I'm going to interrupt myself for a minute and just to say that my Chief Director, Mr. Advocate Sibylle Mecha, and my team member, Mr. Makulubete, is also on the platform. And with your permission, I would like to, at the conclusion of going through this document, maybe hand over to Mr. Makulubete if he wants to add anything. Mr. Chair, in short, with regard to paragraph 2 and the subparagraphs thereunder, in responding to the concerns that the bill cannot at this stage exclude the Supreme Court of Appeal's jurisdiction in hearing appeals from emanating from the bill, we highlighted in paragraph 2.2 the provisions of section 166 of the Constitution, which sets out the hierarchy of courts of the Republic, namely the Constitutional Court, the Supreme Court of Appeal, and then a High Court of South Africa, and any High Court of Appeal that may be established by an Act of Parliament to hear appeals from any court of a status similar to a High Court, and then, of course, the Magistrates' Courts, and then also, importantly, subparagraph E, any other court established or recognized in terms of an Act of Parliament, including any court of a status similar to either the High Court or the Magistrates' Courts. In paragraph 2, we just explain the implication of section 166C and 166E. But more importantly, Mr. Chair, and this is going to be the crux of the matter that we would like to propose to the committee and then also request the committee's guidance, is section 168 of the Constitution. And sub 3A provides that the Supreme Court of Appeal may decide appeals in any matter arising from the High Court of South Africa or a court of similar status to the High Court of South Africa, except in respect of labor or competition matters. Now, Mr. Chair, we refer to clause 34(2) of the bill as it currently stands in the bill as introduced. I'm not going to bore you with the detail or read it line by line for you. We have submitted the document. We also refer to a case that has been decided by the Supreme Court of Appeal. Once again, I don't think we need to really bore you with the detail there. Mr. Chair, and then in paragraph 2.9, we indicate that a concern has also been raised as to what would be the necessity of having a land court of appeal, and if the SCA is given an appellate jurisdiction over land matters from the Land Court of Appeal as it currently stands in Section 168 of the Constitution. And we have indicated to the committee that there will be various options then available, which we highlight in paragraph 2.9 A, B, and C, and then in paragraphs 2.10 and further on, we provide the committee with background information. If I may just go back to paragraph 2.9, Mr. Chair, this is an issue that was raised, if I remember correctly, by the chairperson himself at the previous meeting of the committee. The concern was expressed that it would appear that an extra layer of appeal will be added to the whole structure of adjudicating disputes. Mr. Chair, I'm once again not going to go in too much detail here because the information is available to the committee. The second option is then, of course, the removal of the Land Court of Appeal. And then the third option or possible way forward is then the amendment of the Constitution in similar vein to excluding then the Supreme Courts of Appeals jurisdiction when it comes to competition and labour matters. Now, before we go over to paragraph 3, Mr. Chair, the department would like to propose at the committee at this stage that the committee should consider not proceeding with establishing a Land Court of Appeal, among others, in view of austerity measures that must be taken at this stage. It will be quite a significant amount of money to establish the Land Court of Appeal. And then also it will require an amendment to the Constitution, and that is where we would like to, in a nutshell, request the committee's guidance, whether the committee feels that in the foreseeable future, a Land Court of Appeal should be created, which would then necessitate an amendment to the Constitution. So the department would like to request the committee what the committee's feeling at this stage would be to consider in the near future then a proposed amendment to the Constitution to pave the way for the creation of a proper Land Court of Appeal. When it comes to paragraph 3, Mr. Chair, we've also given background information to the committee that there were discussions when the two bills were developed. And we also indicate to the committee, and I would like to, with your permission, Mr. Chair, focus on paragraph 3.4. So the history of the two bills, they are now running concurrently in Parliament. And we have explained to the committee previously that we are not in a position technically to insert proposed amendments in the schedule to the Land Court bill, referring or proposing to amend a bill which is also currently being considered in Parliament. However, Mr. Chair, and I think you would have noted, I can't remember the exact date, but it's early or mid-September that the National Assembly is scheduled to vote on the expropriation bill. We have had sight of a list of the bill that will be presented to the National Assembly for approval, or rather than the B list eventually. And in that A list, and this is what I would like to highlight to the committee, is that the definition of court will then be amended to say that, a court means a High Court of South Africa, or any court of a similar status to the High Court of South Africa, within whose area of jurisdiction paragraphs A to D may be applicable. So the introductory part of the definition is important, Mr. Chair, to the extent that that paves the way for the Land Court of Appeal to have, my apologies, the Land Court to have jurisdiction in respect of expropriation matters. It might be that in future to clarify that entirely and to ensure exclusive jurisdiction to the Land Court, that the definition might have to be amended. Mr. Chair, with regard to arbitration, once again, by background information, the bill aimed to introduce a compulsory system of arbitration. The department has noted the concerns that were expressed by committee members as well as interested parties, and the department concedes, Mr. Chair, that reference to arbitration should rather be removed from the bill because it will only cause confusion. Arbitration will in any event be available to parties who wish not to get matters adjudicated in the court system, but rather opt for the option of arbitration then. And then there was also a question raised in the committee, and this is paragraph 4.4, Mr. Chair, that or the question was raised whether it would not be possible for a judge of the Land Claims Court to act as an arbitrator. But we have received and we've also drawn the committee's attention to the submission by the Land Claims Court to the effect that the court cannot act as arbitrator. So the department also concedes that this is not an option. So with reference to paragraph 4, Mr. Chair, the department would like to highlight to the committee that the whole reference to compulsory arbitration will be removed from the bill if the committee agrees with the recommendation by the department. Mr. Chair, I'm terribly sorry. I don't know why this always happens to me. Please excuse me for a moment.
No problem.
Thank you, Mr. Chair. And then there was also the question raised about the concept of law and equity in the committee. Clause 3.1 of the bill aims to establish the Land Court as a court of law and equity. And clause, I don't need to refer to, but clause 34 is also there to be noted by the committee. But what we would like to highlight, Mr. Chair, is that these clauses are similar to sections 151 and 167 of the Labour Relations Act, which then, and specifically then with regard to 151, that the Labour Court is established as a court of law and equity. We also refer in paragraph B to section 22 of the Restitution Act, which then also makes provision for matters of equity to be considered. And then also in paragraph D, we quote section 33C of the Restitution of Land Rights Act, where, among others, then factors to be taken into consideration by the Land Claims Court are the requirements of equity and justice. Mr. Chair, once again, research was done with regard to case law. We quote some of those cases there for you. Once again, I don't think it's really necessary to go through those line for line. One would possibly, with your permission, Mr. Chair, then get to the conclusion under this heading, and that is paragraph G, where the department indicates that we are of the view that the Land Court should be established as a court of law and equity, as provided for in clause 3.1 of the bill. Furthermore, Mr. Chair, to establish the Land Court as a court of law and equity will also enable the court to apply equitable considerations when dealing with the admissibility of hearsay evidence, in addition to the obligation imposed on the court to look at the relevance and cogency of the evidence presented before it. The reason why the Restitution of Land Rights Act makes provision for a court of law and equity is then, of course, of the magnitude of the matters to be considered by that court, and we would like to propose that that approach be followed with regard to the Land Court as provided for in the bill itself. Mr. Chair, I would like to conclude under this paragraph and highlight paragraph F for the chairperson and the committee members to note, and that is, it must be pointed out that even the word equity is not included in the bill, the court would still be able to take into account just and equitable considerations in reaching its decision by applying its inherent powers as accorded to it in the Constitution. However, we would like, or the department would like to recommend that the words a reference to equity should expressly be reflected in the bill, and it does not prevent the committee from doing so merely because the Constitution provides for equitable considerations in any event. Mr. Chair, with regard to the conclusion and way forward, we would like to highlight to the committee then, and I'm not going to go through this with you, Mr. Chair, because we would like to say, first of all, when it comes to the Land Court of Appeal, the department recommends at this stage that that appeal structure should not be proceeded with in the bill at this stage, but would like the committee to consider creating a Land Court of Appeal in the near future, subject then, of course, to the committee being amenable to propose or to accept a proposed amendment to the Constitution, and then specifically Section 168 of the Constitution, to provide for that leeway that the Land Court of Appeal can then be a court of final instance. With regard to the whole issue of arbitration referenced in paragraph B, the department recommends that the whole issue of compulsory arbitration should then be removed from the bill. And then in paragraph C, we submit, or the department submits, that the expropriation bill cannot be included under the exclusive jurisdiction of the land court at this stage, since the expropriation bill is also still being considered by Parliament. And then with regard to paragraph D, my apologies, we would like to then focus our attention to the land court and then recommend that that court should be established as a court of law and equity. Mr. Chair, that in a nutshell is our summary, and please excuse me if you feel that I've went through it too fast, but I'm mindful of the fact that Mr. Roberts is also still in the queue, and I would like to maybe leave it at that, and with your permission, maybe ask Mr. Makudubete or my Chief Director whether they have something to add at this stage. Thank you, Chair.
Before you proceed, let's go to the last paragraph C at the end, your way forward.
Paragraph C, yes, Mr. Chair.
Because we are also intending to pass this bill around September. This exclusion of expropriation bill.
Thank you, Mr. Chair. Mr. Chair, you will recall that I've just earlier quoted the proposed definition then that will be included in the expropriation bill. So that will pave the way to a certain extent for the land court to have jurisdiction in respect of expropriation matters. The problem that we're facing at this stage is more of a technical implementational concern, and that is that we can't foresee at this stage which one of the two bills will commence first after they've been signed into law by the President. So it might be that the Land Court Act, if I may call it then, that will commence prior to the expropriation bill, which will make life a bit difficult with regard to cross-referencing to the Expropriation Act or the Expropriation Bill. The solution we see at this stage is that the definition of court will assist us in ensuring that matters may be referred then to the Land Court, Chair.
Okay, no, I'm covered. Mr. Makulubete.
Chair, before you...
Good morning, Chair and honorable members. I'm thankful to my colleague, Mr. Dupree. He has given the summary, and I do not have anything further to add on what he has submitted. Thank you, Chair and members.
Thank you very much, Honorable Maseko Jala.
Chair, I wanted to thank you very much also to Mr. Dupree. I just wanted, Chair, to comment on that issue of the expropriation. I wanted to ask Mr. Dupree if the issue of, if, for example, that matter of expropriation is left in this bill, but also in reference to the expropriation in terms of what the Constitution is saying now. Is there any possibility for that? Thank you, Chair.
Thank you, Honorable Jala. Honorable Niwot.
Thank you very much, Chair. And thank you for the presentation. Thank you for the presentation. So I'd like to ask Mr. Dupree, the Court of Law and Equity, that phrasing, why must that be in the bill? Why must that phrase be mentioned specifically in the bill? I'd like to understand that concept further. Thank you, Chair.
Thank you very much, Honorable Swart.
Thank you, Chair. I just need your guidance. Are we asking questions of clarity, or are we going to engage at a later stage on deliberations? I just, on issues of clarity, the issues around the Supreme Court of Appeal, I picked this up right at the beginning when the department gave its presentation. It's a very straightforward issue. And we are now, if you look at the bill and you look at departments and bodies consulted, this bill was presented by the Interministerial Committee on the 20th of November 2020, now almost 2 years later, when it's very obvious that the Supreme Court of Appeal could not be excluded without a constitutional amendment. Now we're sitting with a situation now that, should it be desirable that the Land Appeal Court asks the Supreme Court of Appeal, it will require a constitutional amendment. We've been under a lot of pressure to pass this bill, and so it's regrettable that almost 2 years later we're sitting with this situation. But be that as it may, it's very clear now that the way forward, as indicated, whilst there are two options, would be to pass the bill as present, to remove the issue, deleting the SCA's jurisdiction, and to then consider putting in due course, the ASTA clause, which would require a constitutional amendment. That would then result in a number of issues which we would need to deliberate. And I just want to ask Mr. du Preez, is he saying that the department is recommending that there should still be a Land Court of Appeal plus the SCA? Or, and clearly it's our option, or would we consider deleting the Land Court of Appeal and having only the SCA until the full Land Court of Appeal is set up? Mr. du Preez pointed out financial constraints, and of course the delay, they would require a constitutional amendment would be required, which would delay the passing of this bill. So I just needed some clarity on the two options and whether the department has, I might not have been clear on hearing the department's specific recommendation. Thank you.
Thank you very much.
Chair, Honorable Wilmer here. My apologies for, okay, the Secretary has fixed the problem. Thank you.
Okay, thank you. Honorable Reichenbach.
Thanks, Mr. Chair. I'm covered by Mr. Swart's input. Thank you.
Thank you very much. Honorable Chair, is it an old hand or a new hand?
It's a new hand, Chair.
It's a new hand.
Yes, Chair.
That's it.
Sorry, Chair, I was confused like Mr. Swart, Honorable Swart, as to the issues of questions of clarity or also getting into the matter. But even if it's like that, Chair, but I wanted, I'm covered by Honorable Swart, but in addition to that, I wanted to find out if, because in the Constitutional Review Committee, there are amendments that are going to be done soon on the Constitution. Is it not possible maybe to liaise with check with the committee and see if maybe when that happens, because that needs 2/3 majority. So even this one, obviously, is going to need that. When that happens, this one also piggybacking on that one, Chair. I'm not sure. I wanted to find out if is there any possibility for that, so that we don't tamper with, we leave the matter as it is on the issue of the constitutional review subject. Thank you, Chair.
No, thank you very much. I think, firstly, we are parties here. Maybe members might want to get mandates from their parties as to the feasibility of changing the constitution, because there is no one party that can do that. we would need a 2/3 majority, as Honorable Jelle has said. But I think for the purposes of the bill now, I think we should proceed as suggested. But I think as we are busy deliberating, I think members would be able to indicate the stance of their caucuses, because if political parties would not be willing, and we might not get the 2/3 majority. So, but we need to pass the bill. So I think it will be important that the issue of the changing of the constitution, members go back to their parties and get a mandate. But in case we do not get that, I think we should proceed with the bill with the exclusion of the Land Court of Appeal and using the Supreme Court of Appeal as proposed. Is that in order?
Sorry,
Yes,
Chair.
I agree, Chair.
Agree.
Thank you,
Chair.
Honorable Swart.
Chair, my only concern is the possible delays there. Even if parties should come back and support a constitutional amendment, that you've got to restart the whole process of this building. And that would be a separate, that would probably be a separate building. So I hear what you say, and I'm not necessarily opposed to that process, whilst obviously one will get a party position. My concern is the delays then in the passing of this bill, should that be the option that we follow. But clearly one doesn't want to preempt the process, but I think in parties' consideration, I think it's important to also note that it will result in a number of delays should that be should the way forward be to amend the Constitution to make provision now as soon as possible. But I leave it for the parties to consider that issue. Thank you.
Thank you, Honorable Horn.
Yes, Chair, I tend to agree with the Honorable Swart. I mean, it's quite clear that in order to amend the Constitution would, in terms of the Constitution, require a dedicated process which entails public participation, and there's specific periods of time in terms of the Constitution which should lapse after a bill to amend the Constitution has been introduced before there can be a vote on it. So I mean, I'm not closing the door on amending the Constitution, and as a consequence, the law to set up a dedicated land court of appeal. But if our interest is now to finalize this as soon as possible, I don't think we have any other option but for now to remove a reference to the Land Court of Appeal. Thanks.
Thank you very much. Any other view on this matter? I think Honorable Jelle.
My question was going to be, if we remove that, Chair, what is the advantage or the disadvantage on this matter? Because the department saw it necessary to include that. Maybe if I can be given an explanation in terms of what will be the negative and the positive of removing that. Thank you, Chair.
Thank you very much. I think if I understand members correctly, and even Mr. Dupree, the issue of the amendment to the Constitution, and the view was that if after we have passed the bill, there is still an appetite to amend the Constitution, but clearly, looking at the Constitution as it is now, you cannot have an appeal court other than the Supreme Court of Appeal. That is what the Constitution says to us now. So you can only have an equivalent of the High Court, and any appeal would need to go to the Supreme Court of Appeal. And I think the issue, Honorable Jelle, if I understand your question correctly, I think the department is conceding that they were wrong with the issue of the Supreme Court of Appeal. That is why they are suggesting the other possibility, which is currently not provided for in terms of the framework as the Constitution is currently crafted, that the Constitution might be amended, which I think would be another long process. And it will also depend on the appetite of other political parties, whether they would want to support that. But the issue is that for now, we need to pass the bill in terms of the Constitution as it is now, if we are to meet the deadlines that we had set for ourselves. Is that understandable, Honorable Chair?
Yes, Chair. I think I'm covered, but now we have to make sure that we assist in terms of capacity, the Supreme Court of Appeal, because now the pressure is going to be on the Supreme Court of Appeal. Thank you, Chair.
Yes, that's true. Thank you very much. Honorable Swart?
Chair, I think Mr. Dupree did add one element there, and that is you have the land court, and then you can have an appeal to a full bench of the land court.
Yes.
Which is 3 judges.
Yes.
Even if the land appeal court is removed. So you would, as presently, if I understand it correctly, you'd have the land court. You could have an appeal to a full bench of 3 judges of the land court. Then you would have an appeal to the Supreme Court of Appeal, as opposed to the land appeal court. And that obviously one wants to bring an end to litigation. Otherwise, and then the final appeal, if it's a constitutional matter, is to the Constitutional Court. So I think there would be an element of an appeal to a full bench as well, which is important. Thank you.
Yes, which is currently happening even now on other matters.
I'm covered, Chair. Thank you.
Thank you very much. Do I understand the committee to be saying we stick with the status quo, the land court, the full bench, Supreme Court of Appeal, and the Constitutional Court?
Yes, Chair.
Yes.
Thank you very much. Let's proceed. Members, is there? Oh, okay. Honorable Dupree.
Thank you, Mr. Chair. There was just, I think, during this discussion, the one question that was raised, well, actually 2, and I'm going to ask Mr. Makudubete to address the committee on the advantage of including the words law and equity in the phrase where it appears. But with regard to the question regarding expropriation and the Constitution and whether there should be reference made of expropriation in this bill, we have explained at a previous meeting of the committee and even during the briefing of the committee that this bill does not aim to really amend substantive law. And as soon as we refer to expropriation and Section 25 of the Constitution, those are issues that are being dealt with in the expropriation bill. And one would not want to include substantive provisions of that nature in a bill which actually deals exclusively with a structure of the court itself. Thank you, Chair. With your permission, I'm going to hand over to Mr. Makudubete.
Thank you.
Thank you, Chair. The issue of equity during this briefing, Mr. Dupree did indicate that we have followed the structure of the courts as contained in the Deliberations Act, in terms of which the Labour Court and the Labour Appeal Court are established as courts of law and equity. Chair, if I may request Mr. Dupree to scroll the presentation to page 10, where the the Nehau case is being briefly outlined, the court said in that judgment, if Mr. Dupree can highlight where the line 1, 2, 3, 4, 5, 6, line 6 from the top, where the court was talking about the old industrial court, which was established by the old 1956 Labor Relations Act. The court acknowledges there that the industrial court, which is the court that was replaced by the current labor court, that industrial court was established as a court of equity, and other matters had to be dealt with in the High Court. However, with the advent of the Labor Relations Act, there was a change of heart by the legislature, in terms of which, when the industrial court was replaced by the Labor Relations Act, the labor court was established as a court of law and equity. In addition to that, the Labor Relations Act established the Labor Appeal Court as a court of law and equity. Our understanding, Chair and honorable members, is that when the court is established as a court of law and equity, the court will be able to obviously apply the law. However, in instances where there will be injustice in the application of the law, then the court will still be able to apply equitable considerations. Now, hence we are of the view that if the committee is still agreeable, we rather have this court, that is the land court, also established as a court of law and equity, and so as the court can be able to apply the law as well as equitable considerations. Hence, then we know, Chair and honorable members, that our high courts have got this inherent jurisdiction, in terms of which they are able to still apply equitable considerations. However, if we have this expression of the court being established as a court of law and equity, it leaves the expression beyond doubt that the court can be able to apply equitable considerations. That is all I can say in relation to this, honorable Chair and members. Thank you.
Thank you very much, Mr. Makolubet. Honorable Jello, is that an old hand or a new hand?
Old hand, Chair, thank you.
Okay, thank you. Members, are we satisfied? Or are there any questions of debate on the issues that have been raised, or we allow them to go and redraft and we look at the polished draft?
Polished draft, Chair. I think we're done with this one. Thank you.
Yeah, I think so. Thank you very much, Mr. Dupree, and to your team for the good work. How much time would you need? Because we can't say you must come tomorrow. I think you have done enough for the week. We will call you. I think the committee secretary will advise. When are we meeting them again after tomorrow?
Chairperson, we were supposed to meet them on the 30th, which is next week on Tuesday.
Okay. So that will it be enough time, Mr. Dupree, and your team?
Mr. Chair, yes, it will. It all depends on whether we get final guidance from our seniors within the department, but we will be able to present a document to the committee on the 30th. Thank you, Chair.
No, your seniors in the department, tell them that the committee is the parliamentary process. So we want a process to be done by the 30th. So whatever they decide, it cannot affect the work of this parliament.
Much appreciated, Chair, and my apologies. I appreciate that. Thank you, Chair.
Thank you very much. Thank you very much, Mr. Dupree, and to your team. Members, it's 5 to 12. Would you want to break for lunch, or should we proceed with Mr. Robertson?
Should we have a break, Chair? Because it's going to be a very lengthy period with Mr. Robertson.
Okay.
I'm in your hands then. I'm in your hands.
Okay. Maybe can you come back at 1?
That's fine.
Thank you very much. We'll come back at 1 o'clock.
Recording stopped.
It's 1:00 on the dot. Members, you are all welcome. And members of the Department of Justice, Mr. Roberts and his team, Dr. Lutz from the Parliamentary Legal Services, and everybody who's watching at home and on the virtual platform. You are all welcome. Members, I thought that you might have received a legal opinion from Dr. Lutz. I think it was not Dr. Lutz, from Mr. Adhikari. It was distributed, I think, yesterday. I would suggest that before we go into the bill, maybe Dr. Lutz take us through the legal opinion, because it has implication on how we proceed. What are the views of the members on that?
Agreed, Chair.
Thank you very much, Honorable Swart. Other members?
Agreed, Chair.
Thank you very much. Mr. Roberts, sorry to, I think let's, Dr. Lutz, are you ready to present?
Good afternoon, Chairperson. Good afternoon, members. Chair, I'm going to do my best. I have a little bit of a technical snag. My laptop's motherboard decided to stop working yesterday. So I have the rough notes that I made on the opinion, but I unfortunately don't have access to the opinion that was sent out. So with Chair and the members' permission, I will relay the gist of the opinion. And if there's any other questions, perhaps I can just supplement tomorrow additional information. Will that be in order, Chairperson?
What was the last part?
If there's any additional information that members require that I don't have access to right now, if I could supplement that tomorrow, if that is in order, but I'll give the gist now.
Yeah, you know, I think the opinion was circulated to members yesterday. If you can give us the gist and maybe be ready to take any questions, then you can, if you so wish, supplement it tomorrow.
Thank you, Chair. Chair, then what we did is after the public hearings, it became apparent that with the cultural and religious concerns raised by the members of the public, that we had to go look at what the impact could be on potential tagging considerations. When the bill was tagged initially, it was done so under the Traditional Leadership and Governance Framework Act of 2003. And since the committee has started working on the bill, the Traditional and Khoisan Leadership Act of 2019 has become operational. So we had to go look at the extended bill, the public comments, and then how that would fit into the new structure of that act. And in terms of section 39(1)(a) of that act, if something directly affects traditional or Khoisan communities or pertains to customary law and customs of traditional, and that will have to be referred, like a bill will have to be referred to the traditional council. And because cannabis has such a strong presence in traditional communities and in the Khoisan communities, our office is of the opinion that given the extended scope of the bill, and with it going forward then, and with the National Assembly having given permission for that scope to be extended and the public coming back with those comments, that the bill has changed in character to such an extent since it was introduced and originally tagged, that we are now in a situation where the committee would need to refer that then for input from the traditional leaders for that community and cultural and religious perspective. And that then is triggered by, or triggers Joint Rule 163, read with National Assembly Rule 286, which gives the committee that power and that responsibility to refer it to the ATM for consideration for referral to the House. I don't have the timeline in front of me, Chair, but that would stagger the committee's consideration of the bill, because the traditional house would have to have the opportunity to consider that extended version and come back then with comments that could impact on how the committee finalizes that cultural and religious section of the bill. We also in the opinion made reference to the fact that depending on how the formulation of commercialization comes out at the end, when the committee adopts the A list, we will have to do a check and see if the JTM needs to be alerted to the potential shift in tagging from 75 to 76. That won't necessarily impact the committee's process now, but once the A list has been adopted by the committee, we need to do an assessment of whether there was a pause, and I'm sure Advocate Robertson will elaborate how that changes, and if that changes with the commercialization in giving guidelines for future legislation. And depending on how much predetermination is in those parameters, there could be the possibility of trade being impacted. But we'll only be able to make that assessment once we have the A list and the wording that has been approved by the committee. Then we could alert the JTM, and going forward, the JTM may say to the national the NCOP that they need to follow a 70 process instead of a 75 process. So what's from our perspective important for the committee at this stage is the Judicial and Khoisan Leadership Act implications, and that we think that House should be alerted through the JTM to the fact that the impact of the cultural and religious extension of the bill now triggers those communities and their interests more so than it did when it was initially tabled and purely had the direction or the view of giving effect to the Constitutional Court's judgment. The bill has subsequently kind of expanded and become a character of its own that goes beyond the Constitutional Court's judgment, and that then gives that concern. Thank you, Chairperson.
Well, thank you very much. So in that legal opinion, you said that will take about 60 working days.
Yes, Chairperson, yes.
The House of Traditional Leaders has up to 60 working days to make their comments.
Yes, but there is a possibility that they do so quicker, but that's what the legislation allows them as a maximum.
Okay. Should I allow members or Mr. Roberts at this time? Maybe Mr. Roberts, so that members can have a fuller picture. Mr. Roberts, do you want to make any comments?
Yes, Mr. Chairperson, I do agree with Dr. Lutz. Bill must be referred to the House of Traditional Leaders, since the proposed clause 1B do affect culture and religion. This was also considered during the drafting of proposals or amendments to the bill. One will see that in terms of the previous clause 1A, which is now clause 10 of the bill, there is a provision that the national legislation that implements commercialization must provide for cultural and religious use of cannabis. This, in effect, then it defers clause 1B, or now clause 11 of the bill that do provide for cannabis for such use. There's also, and I will discuss it later, certain concerns that were raised in respect of clause 1B. And but in general, I do agree with Dr. Lutz. Thank you.
Yes. No, I think at this point, we must generally confine ourselves to this issue of the bill being referred to the House of Traditional Leaders. So members, any comments?
Honorable Swart.
No, Chair, I agree with the opinion. I think the bill has a massive impact on a number of communities. If you take into account the Amapondo communities and the impact that the bill will have on them as well as religious communities, I think it is very important that it does be referred to the House. But then obviously the next question is the possible reclassification as a Section 76 bill. That is a second issue that needs to be considered then. Is that on the assumption that it's reclassified and then referred? Because that in itself is a process. So I just need clarity on that. I'm in agreement of the referral. And does that then mean that we have to wait, or do we continue our deliberations? I would just need clarity on that, Chair. Thank you.
Thank you very much, Honorable Chair.
Thank you, Chair. I think I'm covered. Only one point. I didn't hear the time frame that the bill will be going to the House. Okay, the time frame that we have to meet.
Up to 60 working days.
Which is 2 months.
Just over 2 months, because we have to exclude weekends and any holidays in between.
Okay. All right. Thank you.
Thank you very much, Dr. Lords. The issues. Hello? Oh.
Yeah, I'm here.
Yes, Dr. Lords. The issues that were raised by Honorable Swart.
Yes, Chair. It's basically a two-prong referral situation that we're sitting with now. The traditional aspects and that can go to the JTM. The committee can elect the JTM, and that can go to the traditional house right now. That doesn't change at the moment the 75 tagging aspect. When our office does a tagging opinion, we comment on two aspects, whether it's a 75, 76, or 77. That's the one aspect. And then we comment on whether a bill affects traditional communities in terms of the legislation. So those are two aspects. And at the moment, one aspect of our original opinion changed because the scope of the bill has changed. So it's only the traditional house aspect currently that has changed and needs to be alerted to the JTM. Then once the committee has finalized its deliberations on the bill as a whole, and the A-list has been adopted by the committee, our office can do an assessment as to the actual impact of the commercialization, whether it regulates trade to the extent that it affects the Schedule 4 concurrent consideration or scope of trade. But that's something that we can only do later then. And then once that A-list part is done, then we can, if so necessary, the committee can alert the JTM that there's a potential that the 75 needs to change to 76. So it's two separate aspects that both could potentially impact the original tagging opinion, but the one is not linked to the other one per se. So the committee can can alert the JTM to the fact that it's of the opinion that this bill in its extended format should go to the traditional house for comment and start that ball rolling. And we can continue also with crafting on the bill and working on issues that the committee would like, and then take the comments of the house when that comes in on board to the extent that necessary and finalize the A-list. And then at that stage, we can make a call on whether the JTM needs to be alerted that the impact on the NCOP would change. So it won't, that aspect won't change anything now for the committee, because the decisions the committee takes now on the scope of commercialization will ultimately determine whether it's necessary for the JTM to consider that the NCOP process changes. But that we can only do further down the line. So two different aspects, both speak to tagging, but they aren't like linked necessarily. I hope that assists Chairperson.
Are you clarified, Honorable Swart?
Yes, thank you, Chair. It's much clearer. Thank you.
It's much clearer. Now, Dr. Lords, the process of referring the bill to the House of Traditional Leaders, is it Should we write straight to the House, or it must be via the National Assembly?
Chair, as far as I understand it, but from the committee section side, perhaps colleagues can assist as well, because that's very procedural. As far as I understand it, the rules would allow the committee to alert the JTM. But I will take guidance from the committee secretaries on that aspect, because they know the routes better. So perhaps they can look into the rules and the actual application of the rules and find out whether that has to go through the House or just can go directly to the JTM. As I read it, writing to the JTM should be sufficient, but I will concede to anything they say otherwise.
Okay. Mr. Romano, would you want to answer now, or would you want to be given time to look at the rules and come back with a considered view?
Chairperson, as far as I remember, the rules provide that we can consult the JTM. We don't have to go by we don't have to go by the House.
Okay. Okay. So, which means would I be correct, members and Dr. Lutz and Committee Secretary, that we can't proceed now with the bill? We have to follow that process and refer it to the House of Traditional Leaders via the process as outlined by the Committee Secretary, which would take anything between a day and 60 days, 60 working days. Then thereafter, we would consider the bill with the views that would have been expressed by the House of Traditional Leaders. It's important that that House is a creature of statute. It should be respected as we respect public comments, that we allow that time. We know that we would have loved to finalize the bill now, but I think the failure to observe that particular process can be fatal to the whole parliamentary process of dealing with this bill. So it's important that all technical and procedural aspects are correctly followed, so that the product is as good as the process. Would that be in order, members?
Yes, Chair. And if our secretaries can start as of now or yesterday, so that maybe it might happen that it won't even take that 60 days.
Yes.
Thank you.
Thank you very much, members. Is there a contrary view to that? No. Yes, so the committee secretariat, we will work together to ensure that all procedural aspects are adhered to, and JTM is informed, and the bill is transmitted to the House of Traditional Leaders. And when we have received comments from them, then we will be able to reconvene again and work through the bill. That would have an impact on the program. One of the reasons why we did not bring the program for adoption today, it was partly this issue, because we wanted to get the guidance from the committee and the committee decision, and also to receive a report from the legal services on the bills that have got constitutional court deadlines. Because I think waiting for the department to bring bills, I think it's also not working to our favor as Parliament. And I think members would have received an opinion on the Sonke judgment, which places responsibility to pass bills squarely on Parliament, not on the executive. So we thought that we must get a briefing from the legal services to say which other bills might have constitutional court deadlines between now and end of next year, because 2024 might not be, I don't think Parliament might be meeting to pass bills or laws. So we must use this time and end of next year to ensure that we try and meet all court deadlines. Already we are in serious trouble with the JICS bill, but we will discuss that tomorrow. So that will have an impact on how our program is going to be, because, for instance, we have to take out now all the days that were set aside for this bill, and readjust the program and ensure that other things are included in the program. That is the reason why we did not adopt the program for the term in the first day of the sitting. I hope members would understand. Any comments, members?
Steve, sorry.
Yes.
Thank you, Chair. I appreciate that. Have we dealt with the? I appreciate the fact that we will not be able to continue deliberations on the cannabis bill. I just wanted to find out, when it is now referred to the traditional house, do the submissions that we've already received from various traditional leaders, are they included in that reference? There's a lot of concern amongst our Mapondo community and others. So I just wanted to understand, I suppose we have no input on that process. That will be guided by Mr. Robertson. Do we have any information about that process of submissions that we've already received relating to that being passed on? Maybe it's best just to say that's a possibility, that some of those submissions that form part of already the public submissions should form part of the discussions with the traditional house. But we can't dictate how that should happen, I presume. But on your broader context of the program, I am in agreement with the fact that we haven't finalized the program. I share your concerns about the Constitutional Court deadlines. I was taken to task, I'm afraid, in the WIP's meeting because raising these issues, that I was accused of being the WIP for the Justice Committee, which I'm not. These issues of Constitutional Court deadlines have been raised. They were raised as part of the training of members. It's a high level, but the mechanism I don't think is there sufficiently. And when you consider the postponement decision in the electoral bill, the Constitutional Court made it very clear that it's not good enough for Parliament to say we're waiting for the executive. Parliament itself must pass bills, even if it's a committee bill. So in granting that extension in the electoral bill, reluctantly, the Constitutional Court said it's up to Parliament now to step up its game. And I think that is the challenge we're sitting with that Correctional Services, the Sonka judgment. So I'm in agreement with you, Chair. Thank you.
Thank you very much for pushing that agenda for Parliament. I think they were wrongly accusing you for being a whip of justice. You were really pushing an agenda that Parliament should be seized with, because sooner or later we are going to face a serious crisis, because some of these Constitutional Court bills, in fact, judgments, there might be a serious gap in the law, which can create serious havoc. So it's important that Parliament should really step up its game. It's very important. So I do think that even in the last budget vote, we did raise the issue, even about JICS, and we've been raising it since the start of this term. where we received bills very late from the executive, including this one, the cannabis bill. It arrived, I think, a week or days before the deadline. So I do think that that issue is very important, that Parliament should really step up its game and ensure that its responsibility, it take it very seriously. But you asked a question. I'm not sure whether Mr. Roberts or Dr. Lutz has the answer.
Yeah, I'm not sure as to the extent of the information to be referred, but I can't see a harm in making that information already before the committee and shared with regard to the communities and their interests available to the House. But once again, I will defer and concede to my colleagues from a procedural perspective, but from a legal perspective, I can't see how more information will be harmful in that extent.
Okay. I think the Secretary, Mr. Dupree, do you want to say something?
Mr. Chairperson, no, nothing. Look, in terms, if the bill is usually referred to the House of Traditional Leaders, it's merely the bill itself, the text, that should be referred to that House. And they consider the bill as is without taking into account the submissions. But as was indicated, there's probably no harm to submit the comments that were received to the House of Traditional Leaders. Thank you.
Yeah, but if we submit the comments that we have received, most of those people are their subjects. So won't they have their own processes of getting views from their own people and respond to the bill accordingly?
Yes, Chairperson. I assume they would have their own internal processes, but I don't know if Mr. Roberts can assist. I'm not privy to those processes, so that is a possibility.
Yeah. Look, I'm not averse to us doing things in a transparent way, but let's make sure that in doing so we don't create other unintended consequences. Well, I do think that the intention was that the bill should be referred to the House of Traditional Leaders. Now, if you take the comments from a particular section, others would say why our comments have not been also referred to. So maybe we might open another can of worms. But if the committee feels that no, that is the right thing to do, is fine. But I thought that the best way would be to refer the bill to the House of Traditional Leaders, and they look at their own internal processes of how they respond to the bill as referred to them by the committee.
Chair, maybe that is the wiser approach, given the fact that we've got lots of different submissions. Yeah. And I would presume what I was referring to was specifically submissions from leaders of traditional communities. And I think they would, of their own accord, respond to the invitation that the traditional House will then extend. So I think it is a wiser approach, maybe not to refer all the submissions because of what you're saying. So I withdraw that request. But I'm sure that in the normal course, traditional houses such as the Umapondo will respond, given the fact that they've got a very intrinsic interest in this matter. Thank you, Chair.
No, thank you very much. Thank you very much, Honorable Swart. Honorable Taylor, is that a new hand or an old hand?
It's an old hand, Chair. Thank you.
Oh, no, thank you very much. I think, members, we have come to the end of the meeting. Tomorrow, we will only be dealing with the legal services. The issue we've just dealt with now, because they will have to brief us in detail about the bills, in fact, the court deadlines that are before them. So that will be the only item. So it will be quite a quick meeting. The other issue is that in terms of the program, but it was never communicated to you in terms of the invitation. The program indicates that on Friday would be meeting, but that has been postponed because we're informed that the Women's Parliament is sitting on Friday. So we will have to find another day. So with the program the program the way it is now, there will be a lot of redrafting. So we'll find another time to accommodate that issue that we're supposed to deal with on Friday. So members, the meeting is adjourned. Thank you very much.
Thank you, Chair.
Thank you very much. Thank you, Moido.
Moido.